As a non-resident Indian, as an NRI, are you trying to figure out how to obtain a succession certificate in Telangana? Are you trying to understand what are the timelines involved? What are the documents that are required? What is the cost that is involved? Are you trying to understand the difference between a legal heir certificate and a succession certificate and a family member certificate and all the other types of certificates that you've come across on Google? If these are the things that you're trying to understand, you're in luck, because in this video, I'm going to be talking about how to obtain a succession certificate in Telangana. My name is Ramana Reddy, and I'm a practicing lawyer in the High Court of Telangana. For tips, tricks, and general legal information, make sure you hit the subscribe button below. So let's take the classic example. Let's say that there is a husband, wife, there's a son and a daughter. Let's say the husband owned shares in, say, Infosys, and he has a huge portfolio. Now, unfortunately, the demat account or the physical shares of Infosys do not have a nominee. So what happens is now these three legal heirs approach Infosys or the registered transfer agent that deals in Infosys shares, and they tell them, that look, we are the legal heirs, so please transfer these shares in our name. 99 out of 100 cases, the registered transfer agent is going to say, look, I don't know who the legal heirs are. I don't know the identity of the legal heirs. Now, three of you say that you're the legal heirs, but how do I know? So what you would do is the RTA would tell you to go and apply for a succession certificate and bring the succession certificate back to them so that they could process the claim and they could transfer the ownership of the shares, mutual funds, the bank accounts and so on, that they could transfer it to your name. So this is the classic case where you would need a succession OP. Before we talk about how to obtain a succession certificate, it is important to understand that a succession certificate is only in respect of stocks or, bonds or fixed deposits or bank accounts or gold or any other movable property. If the person who has passed away has land and building on his name, then what you need to do is you need to file a different type of case, which is called a legal heir certificate, loosely. But you need to file a declaration suit and so on. If you're interested about that topic as to what happens when a person who has passed away leaves behind land and building and what is the process, make sure you click the link somewhere above where I talk in detail about what the process there is. But in this particular video, our focus will be what happens when a person who passes away owns these financial instruments that are to be transferred in the name of the legal heirs. In order to obtain the succession certificate, what you would have to do is you would have to approach a civil court and file an original petition under section 372 of the Indian Succession Act, asking the court to grant a succession certificate, in our case in favor of these three legal heirs. So that is basically the procedure where you would have to file a succession OP, as it is called. Now, as an NRI, what is something that is different for you as opposed to the regular person who's situated here? Now, we'll go point by point, and in each point, I will tell you what the differences are. Let's talk about in which court you would file the succession OP. You would file the succession OP where the person who has passed away was ordinarily resident. So let's say, for example, the person was ordinarily resident in Hyderabad, and he passed away in Mumbai. Then you would file the case in Hyderabad because he was ordinarily resident here. Or if the person was ordinarily resident abroad and he passed away abroad, where was he resident before he left India? So, and where is the address in the AADHAR card? So these are some of the things that are important to keep in mind as to in which city would you file the succession OP to begin with. Now, moving on from which court you would file, the next thing would be who would be the parties to the case. Now, the parties to the case, let's say going with our example, it could be the wife, the son and the daughter. So these three people would be the petitioners because they are bringing the action to transfer ownership. The respondents would be the registered transfer agent who's refusing to do so. And you would also have someone called all concerned. Now, what does that mean? So what that basically means is that, the court has no way to determine who the legal heirs are. So the court will issue a public notice in a newspaper saying that these three people have approached us saying that they're the legal heirs of this particular person. If somebody else has an objection, please come forth on so-and-so date and state your objection. In 99% of cases that I've seen, I've never seen anybody come forward with an objection. But anyway, that is the process to identify the legal heirs. Now, as far as parties are concerned, there is no real difference when it comes to a local person and an NRI. Now, moving on, what are the documents to be filed? Now, here there is a difference. Now, before we get to the difference, let's talk about the similarities. You would have to file the death certificate, number one, of the person who has passed away. Whether he has passed away in India or abroad does not matter, but you would have to file the death certificate. If you have AADHAR cards, definitely you have to file the AADHAR cards to show that in fact that that all of you belong to the same family, because it may say that you're the son of so-and-so, you're the wife of so-and-so, and so on. The other thing that you would need to file would be, if you have a ration card, because that usually gives out the details of the family members, then you would have to file the ration card. Before you come to court, it is important that you write an email to the RTA or the registered transfer agent requesting them to transfer. Because when you go to court, you should be able to say that, look, I've addressed an email to them. They have either failed to respond or they have responded saying, get me a succession certificate, which is the whole reason why I'm here. It's always good to have some documentary proof in hand, because the court may say, did you even approach them? Like, are they insisting for one? Why are you here? You don't want to be in a position where you say that I met them orally and they said, get a succession certificate. It's always better to have something in writing. So it's advisable that you send out an email before coming to court, and preferably if there's a reply from them getting a succession certificate, you would also file that as part of the documents. Now, this is where the commonalities end. Now, the difference would be, let's say if you're living in the US or UK or Australia or wherever, you cannot physically come down to court, because you'd have to come down to court once, or you have to sign documents and so on. And you can't do that when you're sitting over there. So what do you do then? So what you do is you execute a general power of attorney in favor of somebody you trust, a family member, for example, in India, so that that person can represent you and he can fight your case on your behalf. Now, how do you execute the GPA? I mean, you can execute a general power of attorney, but once you do that, let's say, for example, for the sake of just simplicity, if you're based in the US, what you would have to do is you would have to take that document to a public notary in the US, and the notary would notarize the document, and you would have to courier the document back to your trusted person in India. The trusted person in India would carry the document to a district registrar, and he would validate the document. That is a process that happens in India. So because the document is coming from abroad, to authenticate that it is genuine, a local person would take it and he would submit it to the district registrar, who would put a seal on it as authentic. And it is important, please keep in mind, do not lose the envelope. You must tell your trusted person in India to be careful with the envelope in which you send the courier, so that, because the district registrar is also going to ask for proof as to how it got here. So that is something that is different for a regular person as opposed to an NRI, because you're not specifically here. You have to appoint somebody to represent the case on your behalf, and you have to issue a GPA. And to do the GPA, you need a public notary and you need validation here. That is as far as documents are concerned. Now, moving on, court fee. Court fee, there's no difference whether you're a local person or you're an NRI, because the court fee, and this is what pinches people, but this is why you should have a nominee. If you don't have a nominee in your accounts, then you have to come for a succession certificate. But the court fee is 6%. So let's say the value of the shares is 1 crore, then the court fee will be 6 lakhs that is payable to the court. Now, there is, I guess, some leeway. In all other cases, court fee is payable on day one. On the day you approach the court to file your case, your court fee is payable at that point. But in a succession OP, what happens is you get some time. So you don't have to pay the court fee, the 6 lakhs, for example, on the date of filing the suit, but you can delay payment till the date of the decree. Now, it is important to understand when you say you can delay payment till date of decree, that does not mean that the court will release the shares in your favor. You can sell some of the shares, use that money to pay court fee. No, you have to pay court fee before the decree is passed, before the ownership is transferred in your names. I guess the only advantage is that, as if the succession suit or the succession OP takes 6 months, 8 months, 9 months, then you at least have that much time to plan and arrange for funds. Now, the next question again is, how long does it take? Like I was just saying, again, there's no difference between an NRI versus somebody who's locally available. We are working with courts here, so there's no one-size-fits-all timeline, but generally takes about 6 to 8 months if things go smoothly and all documents are in place. So I hope that was helpful. Those, I think, are the major differences when it comes to like a local person filing for a succession OP versus an NRI filing for a succession OP. The major one, I think the major handicap being that the NRI will, is not physically present here, and you would have to give a GPA in favor of a trusted person. So you would have to identify a trusted person to begin with. And there's this whole process that you have to undertake. I hope that was helpful. If you want more information on how to obtain a legal heir certificate or a succession certificate in Telangana, be sure to download the free ebook that is available in the description below.